Welcome. This is another Green Law Group webinar in our series. We've been seeing a hot market in real estate, so we wanted to cover some of the pitfalls of what that you may avoid in real estate transactions that are going on right now that you may be involved in. Oops, I went too far. This webinar is sponsored by the folks at Easy Law and Builders Book, the Blue Book of Ventura County Credit Union, and the Ventura County Contractors Association. We're not presenting legal advice per se in this presentation. More general information. Legal advice would pertain to specific information about a dispute or problem that you may be having, and we would be retained in order to represent you and give that legal advice. So with that caveat, we are a full-service business litigation and transactions firm that deals primarily in real estate, construction, and employment law matters. We represent a fair number of contractors and other real estate professionals. We do license setups and for contractors, we also do corporate work, LLCs and corporations. We also were doing wills and trusts these days and some other probate work. So I think we are at 8 attorneys now, and going to start off with just an overview. I went through kind of what's been going on in 2021, what's been hitting my desk, what are the issues I've been dealing with here as a partner. We've been getting a lot of tenancy questions, leases in default, both commercial and residential. We're also anticipating with the removal of the moratoriums on mortgage foreclosures and evictions, unlawful detainers, we're anticipating that real estate transactions will kind of be back in kind of the realm that we were in 2008. Maybe not to the extent or degree, but it is something to consider. We do have extreme market trends at this time that we're dealing with. We're going to discuss some of that. We're also seeing a fair amount of flipping and inventory, lack of inventory. So properties are being pushed to market maybe before they're even really complete, and even entering into escrow while construction is going on. So I want to discuss some of the ups and downs of that as well. We're also anticipating in this kind of market where there's low inventory that people are going to be looking more and more at the distressed property markets like we were in 2006 and 2007. So I want to cover a little bit of that, what pitfalls, what buyers and other professional real estate professionals need to be concerned about in dealing with distressed property sales. I'll give a brief rundown of the new laws that may impact some of real estate transactions for 2021, and I'm going to talk a little bit about Prop 19 too, which has come up. So that's our presentation today. I'm anticipating it'll be about a half hour, and then I'm open to questions at the end of it. So talking about default leases, we went through this now year and a half almost of substantial loss of employment and economic freeze essentially during the COVID crisis. There was a bill passed in the legislature in California, the Tenant Homeowner and Small Landlord Relief Stabilization Act, which basically put a moratorium on both residential and commercial tenant evictions. That was extended for residential and in the SB 91 COVID-19 Tenant Relief Act back in February. And that moratorium on evictions lasted through, it's expiring June 30. So effective July 1, there will no longer be, unless the last minute it's extended. I don't have any word that that's going to happen, but tenants are going to have to be paying rent again. So the other thing, so with respect to residential tenancies, that expires June 30, there's also an executive order N0321, which is expiring, which ends the moratorium on commercial evictions as well. So starting July 1st, tenants will have to pay the full amount of rent to be protected from eviction. So whatever their rent amount was per their lease, they need to start regular payments. There was a process put in place to protect tenants from eviction, whereby they basically separated their money claims from the right to evict. And as long as certain procedures were followed by the landlords and affidavits were submitted by the tenants, landlords were still going to be able to make small claims cases to uncover their unpaid rents. With respect to these claims, these small claims, there's no jurisdictional amount. So if they're owed, arguably, normally small claims is subject to a $10,000 jurisdictional limit, $5,000 for entities, businesses. Those caps are basically tossed away in SB 91. And so whatever the amount of the back rent is, you can go to small claims to try and collect it, even if it's over the jurisdictional limit. From a transactional standpoint, why these leases matter is because when you're selling the property, you want to have a very good picture of, if you're a buyer, what the tenant conditions are for whatever the property is, be it a commercial, multifamily, commercial, some other, business or industrial unit, or whether it's a residential, single-family home residential property. You're still going to want to know what the status is of the rental payments. And so you need to make sure that you insist on that during the transaction process when you are doing your due diligence and are going to waive your contingencies. You want to make sure that you get proper estoppels, and that those estoppels should include whatever the notices were that the landlord sent and proof of mailing, as well as the affidavits received from the tenants and what they said. So, and you want to make sure that all that information is accounted for and up to date, consistent with at least through the period of the signing of the contract for the sale of the property. I would also say that you should consider taking assignments where you're buying a property that has an existing tenant who may have been in default. Through this period here, you may be inheriting a tenant that has financial problems, but you may not have some prior, there's nothing carrying forward in terms of a right to evict because of these moratoriums. So to the extent that you're going to take possession of the property as the new owner, you may want to take an assignment of those written claims against those tenants, so that you will have more leverage, then, so to speak, in dealing with those tenants and getting them, either evicted or, well, not necessarily evicted, but at least leveraging, so to speak, whatever those claims are to get them to voluntarily vacate, or, sorry, I've been trained best. Or we may, that also may have value, but it's an uncertain value as at the time that you're taking possession. So it will be difficult to set the price for it, because you don't know what's collectible at that point. So, consider the written assignments. That's something that you should really consider having a lawyer assist you in drafting. We'll deal with some more assignment issues later on when we get into some other topics here. The other recommendation I would have is if you're a landlord or a tenant, you want to find out if anybody has applied for housing assistance. There was rental assistance of about $2.6 billion to California households that was passed. And there was also from the stimulus bill, I think part of that $2.6 billion was federal monies. I think it was about $1.4 billion or so. And in order to qualify for that, there needs to be certain demonstrables in your application. Income at or below 80% of area median income. You need to be able to tie whatever the financial difficulty is to the COVID-19 pandemic. And you need to be able to demonstrate that the tenant is experiencing a risk of homelessness or housing instability. If the landlord applies, they can recover up to 80%, but then they have to release all other outstanding debt that the tenant may owe. The tenants applying, in the federal guidelines, they're limited to 25% as far as I can determine. The tenant notice deadline, the landlord's notice to tenant deadline for housing assistance was February 28th. So you want to make sure that whatever the information you're being provided in the estoppels is consistent with these forms and these requirements, and that the notices were properly and timely sent to the tenants. If you ultimately, after July 1, if the tenant continues to not pay their rent, then you'll begin to accrue, and then you can serve. Technically, you could serve a 3-day notice to pay to quit, but during the moratorium, theoretically, it would have been 14. It's complicated, but we're recommending people serve a 30-day notice if they're under a year, and 60 days if they're over a year to quit. If they are in continuing breach. So, and particularly where, they're not under rent control. If they're under rent control, then that is a much more complicated problem, okay? And that is really governed by whatever the jurisdictional rules are for their local RSO rent stabilization, ordinance is. And that would require you to consult, in my mind, an attorney who deals with evictions regularly. Our office typically does commercial evictions, and rare instances we'll do residential, but you can certainly talk to us and we can point you in the right direction on who to go to handle your eviction matter, okay? If it's not our office. The moratorium on foreclosures and the mortgage payment forbearance period is also ending on June 30. So we're expecting to see foreclosures, short sales even, possibly bankruptcies again, and that market heat up a little bit. Now, I would say that there's probably some lead time, depending on what the status of the default notices are and the sales. But we anticipate by the end of the year there isn't some other financial relief from the state or the federal government on foreclosures, we're anticipating that we're going to start seeing, foreclosures picking up. And I'll have more to say about that from an investor developer type transactional perspective later. But we're also anticipating, we do some bankruptcy creditor work here, and we are anticipating seeing landlords possibly filing Chapter 11's Subchapter 5 reorganizations for some of their issues that have arisen, because when tenants haven't been paying, landlords also have not been receiving rent, and they may in fact be in arrears to their lenders on their mortgage obligations, and maybe their forbearance is also expiring too, so they're in kind of a tough situation. Subchapter 5 is this part of this new law that was passed in February of 2020. It's relatively new. There hasn't been a tremendous number of filings yet on it, but it does have certain limitations. The limitations were expanded during the moratorium phase through the CARES Act. It was up to $7,500,000, but I believe that expired back in March. So we're just at the statutory limits for non-contingent and unsecured debt at this point. So, but if you're a landlord and you're dealing with these issues and you'd like to consult with us, feel free to give us a call. If we don't handle your matter, we'll be happy to refer you to somebody who would. So, but we do handle certain bankruptcy matters here as well. So, in dealing with the current pitfalls in the real estate market, the biggest issue in a red hot real estate market is lack of inventory. I'm a member of the Southland Regional Association of Realtors. I have a broker's license. I'm reading their market reports, and it looks like we had a record back in February, the lowest inventory in the history of the SRAR. They're reporting. So there were only 629 listings in the San Fernando Valley area in February, and it's tricked up a little bit and down, and I blow it, but it tricked up a little bit since then, but not much, and certainly not enough to go into the summer rush, so to speak, for property sales. So an active inventory is down, 27, a little over 27% from a year ago. So we've got this issue of inventory for sale. At the same time, we're in the middle of a huge construction boom that began really during the COVID crisis. It's very difficult in our area here in Southern California in particular, on North and West Los Angeles County, to find, competent qualified contractors. They're just really, not enough of them to go around for the amount of demands. And the same is true for subcontractors and skilled employees. Meanwhile, bid costs have been going stratospheric. Inputs overall, labor and materials have gone up year over from the first quarter of 2021, from the first quarter of 2020, nearly 13%. And my understanding is the second quarter is going to be even worse. And we've been seeing material spikes. I've indicated a few here: fuel, 114%, lumber and plywood, 62%. It's actually lumber and plywood, somebody was telling me the other day, is up around 81%. And I'm hearing that PVC for pipes and other products is up over 270%. So we're talking significant price spikes. And so all of the costs of improvements when people are fixing up their homes for transactions, are going up. So the floor on profitability for sales, particularly where those improvements are taking place, is going higher, which is pushing the market prices up. Median prices, I didn't include them here, but median prices, for Ventura County are up over, I think it's nearly 740,000. They get LA, it's up around 810,000, something in that neighborhood. This is significantly well over where we were a year ago. And so, meanwhile, we have had a pretty substantial labor hit in California. We've lost 2.7 million jobs during the COVID crisis. We've gained a little bit of those back, but they're made primarily in low wages, less than $100,000 per year, those categories. But we're seeing very low rental inventory stock, very low condominium, entry-level type properties, or are few and far between, hard to find. And my understanding is the prices of condos are up over about 19% from last year too. So fewer buyers, so to speak, or qualified renters, and less and less housing stock. And then we indicated here a lack of skilled trade workers too is impacting labor costs, that we're dealing with. Those are also people that would typically be paid, that could maybe afford to buy a home. The more of those skilled trade workers you have, the more potential buyers you have, theoretically. So the other thing we've been seeing, obviously, is in this flipper, construction boom, is an increase in defect claims. I'll just generally tell you that it seems like everybody had to go get a new pool or spa, and during the COVID crisis, and my pool contractors are going bonkers right now and trying to keep up with demand. And I'm seeing a lot of, kind of fly-by-night contractors, not documenting jobs, not properly supervising jobs. It's been, they maybe have irons and too many fires. Given that we defend, hundreds of contractors, we're end up stuck, trying to bail them out of those situations often. And, I would tell you that the natural result of that, as we saw in 2006, 7, and 8, is an increase in defect claims. So we're seeing a lot more insurance work and, bad faith claims and things like that. Insurers are tightening up. And so that's a market trend too that we deal with here as we deal with breach policy and bad faith actions and represent contractors against insurance companies. So that area of our practice is starting to heat up a little bit. I would encourage any contractor that is dealing with claims of defects, they contact us, preferably even before they contact their broker or their insurance company. Promptly let us know so we can frame their tender to their carrier properly so that they can get coverage. Because we're seeing a lot of denials out of the industry, of coverage and the defense. We're also seeing, because of the lack of inventory, people pushing properties to market before they're really complete. We're seeing a lot of purchases out of escrow, where there's construction still continuing during escrow, and that creates kind of the third-party beneficiary problem, where the seller and the contractor have a contract, Now they've introduced a buyer, and now the buyer wants certain things, and they're making changes, and who's paying for what. How is the buyer going to contribute? Are they going to increase the price? Is there some other means that it's also monkeying up the mortgage qualification process, because you can't get a mortgage if you don't have a final and certificate of occupancy. So they're rushing through their finals on the minimums, but there's often still, the pretty work, the finished work, some stuff that isn't required for a final still ongoing. And then now the property is changing hands. So, you need to have competently drafted assignments of the builder's contracts and warranties. You need to consult with a lawyer. You cannot rely on your brokers. I mean, brokers are very good at what brokers do, and agents too, not to deride them, but these are legal issues. These are contract issues. They really require the assistance of a lawyer. And I think most brokers and agents would immediately send you to the to the lawyer if they are seeing this. At least I would hope they would. It's important for a buyer where they know that they've purchased a property from a flipper. Okay, if it was an owner builder, that was doing the work, or it's a flipper, to get whatever trade contract information they can during the disclosure process and the transaction. Somebody just spent $150,000 on a remodel. You want to know who the subcontractors were. You want to see their certificates of insurance. Okay, if it's the work is happening during escrow and you're a third-party beneficiary as a buyer, maybe you even want to get additional insured endorsements from the carriers, because once it transfers over, you're going to take that assignment. You'd like to be standing in the shoes of the insured as well. Okay, and it's simpler maybe to just do that, and attempt to get the additional insured endorsement. These are complicated problems, and it takes a certain knowledge of the construction industry to deal with these problems during the construction period in an escrow, okay, and where there's carryover with the new owner, versus the old owner. Sometimes what I'm seeing is there's holdbacks during the period of whatever the sales proceeds are in escrow until the construction work is complete. That creates a whole panoply of other potential problems too, because the contractor who has the contract with the owner, the seller, well, that person's no longer the owner, okay, after closing. And if it's based on merely a holdback, then that needs to be languaged appropriately as well, and there's certain legal requirements for that. So, please, I'm begging you, call me early, okay, and call me often, before these problems become, much more expensive to unravel. The low inventory is also, this is more, my speculation, but it's an informed speculation. I've been doing, real estate transactional work, either in the construction industry or the real estate industry, the better part of my adult life, reaching back into, late 80s, early 90s. So, I've seen a lot of boom and bust real estate markets. And I'm anticipating that when we're starting to see more foreclosures, potential short sales, more bankruptcies, the people, but we still have a low inventory cycle like we did, in 2007, 2008, even into 2009. That buyers are going to be starting to look at properties that are, not listed on the MLS, or they're distressed properties on the MLS, and they need to have a pretty solid understanding. Probate, bankruptcy, tax sales, these distressed properties subject to those things all have a whole other separate legal framework, okay? They're not like your typical transaction, and brokers and agents need to be careful. Buyers and sellers need to be careful and not think of these types of transactions as strictly just like any old MLS, straight up standard sale. You know, you really want to deal with brokers and agents or other professionals who have experience in these areas, direct experience over years, okay, to deal with those problems. You know, I spent years myself kind of specializing in probate and bankruptcy and tax sale type properties. I worked at a prior firm on a property tax sale case, went all the way to the California Supreme Court. But you know, the types of issues you're going to need to be concerned about, understand that if you're getting into probate, that you need to prioritize direct sales, you know, from a trust or an executor who has authority to sell in the will, expressly in the will, okay? So that these transactions don't require court approval. If you're going to start bidding or becoming what's called a stalking horse buyer and go through the probate auction process, or not auction like the court, basically the court approval auction process. They basically set up where there's no IOLTA authority for an executor, or it's an administrator, meaning there wasn't an executor named in the will. If they, if the property has to be sold, then they go find a buyer, and that buyer, you know, puts an offer in on the property. They take the offer to court, and the offer is accepted at some percentage. You know, they basically open it up to a court sale, and anybody else that shows up can bid on the sale. Well, the process of getting from the offer, you know, submitted to the court, so that can take weeks or months, okay? And you can tie up your transactional monies and your proof of funds, so to speak, you know, in the probate process for a period of time. You need to be prepared for that. You also need to be prepared to be outbid bid at the court proceeding. There's all other pitfalls involved too. There was a lot of, you know, a lot of administrators, some executors also ship their property to probate auctions. Flans and Wiener is one of the auction companies. There's a few of them out there, a couple of them anyway, here locally. And, you know, that is a whole other market area that has its own ins and outs and important information that you would probably need to know. So if anybody is going to be getting involved, certainly in the you know, probate transactions and acquisitions, they should probably have a good lawyer that has some experience in that. You know, I'd like to hope that I'm that guy. So feel free to give me a call. If you're going to get into that area, we should discuss it in more depth. The same thing is true, all the same issues pretty much that you're dealing with in probate as far as court approval and, you know, an in-court auction setting or bidding setting is true for Section 363 sales. You know, there you get the benefit, you know, creditors get to credit bid, okay? And there's even more complexity in that too, because while you have the advantage for most of these are free and clear of 100% of the value of the asset, meaning that the bankruptcy court, which is a federal court, which has supremacy, okay, gets to wipe out all the liens through the bankruptcy process on the property and hand you a free and clear title. There are scary exceptions to this that I've actually run into over the years of problems with this, where there was free and clear on only a partial interest, like a tenancy, you know, where ownership was held in tenancy in common, for instance. There are other situations too. So even there, you need to do your homework and be able to read the bankruptcy documents and understand the creditor work. So, and the creditor status, you know, in order to properly handle these Section 363 bidding opportunities. And yes, you can get some good deals in these occasionally, depending on how much pressure there is, how many people are participating. But it's, that's another complicated area, another area you want to talk to me about, or another, qualified lawyer with experience in this area. Finally, I would just mention tax sales. Every summer we have a tax auction in LA County. There are different times for different auctions all over the state. Property tax sales, are, the right of sale in most jurisdictions is I think 5 years. You have to look at it county by county. A lot of these properties are, they issue a book. It used to be a book back in the good old days when we still had paper. Now there's a list, but there's 4,000 or 5,000 properties, in LA County. I'm guessing, but maybe it's 3 to 5 in any given year that are published. But most of those redeem. Maybe 80–85% of those properties redeem, meaning the taxes get paid before the auction date. So if you're an investor thinking you're going to start getting into tax sale properties and you see all these residential real properties sitting out there ready, there are strategies for taking down properties. They require a lot of upfront work, some title work. The thing that you need to understand is these properties that you take at tax sales, basically they get tax clearance, okay, for the property taxes and nothing else. Okay, you're taking title to these properties, warts and all. Okay, maybe they have environmental issues, maybe they have a title problem, maybe there are other encumbrances, maybe there are code violations, red tag issues, maybe there's a tenant, that you're going to have to evict. Okay, and then there are also buyback rights that the tax, the payer, the prior owner has. So you have to take those into consideration too. These are not quick sales. They're not. Yes, you can make a fair amount of money on tax sales, but you need to be very sophisticated and not just think you're sophisticated, but actually be sophisticated and probably be a real estate professional. And you can get your feet wet in these things, but don't go whole hog until you've really had some time in on them. The other thing I would suggest is you have a good, strong legal budget because these properties tend to be subject to litigation. And you also need to understand that, most of the in a hot market where people start paying attention to alternative areas like tax sales to acquire properties, I've watched residential homes get bid up over market, in the frenzy of uninformed bidders in the first day of the tax sale. And, I just sit there and shake my head. Okay. So, that understand that there will be other people there that may be bidding too on those properties, and they may or may not be seeing the same things you are. So you don't want to get lost in the euphoria of the bidding process. You need to have a strategy. Okay. Any questions about any of these areas, feel free to give me a call. We can talk about it. I'm also going to go over some new laws that are impacting residential transactions or real estate transactions in general. This first one, SB 1079, the 15-day renter's right of first refusal on a foreclosure for auction buyers. This is an interesting new law. This is basically to Wall Street and the hedge funds that came in to buy up, distressed foreclosure properties in Southern California, Northern California, circa 2010, 2011, where, folks who've been going to auctions suddenly start seeing big money guys showing up and bidding everything up, buying up the stock in the depressed market. So the legislature, in its infinite wisdom, was concerned about that and set up this SB 1079. I haven't been involved in any actual use or enforcement yet. It's all kind of theoretical to me at this point. But I'm going to put it out there because if the buyer at the auction, and they're going to have to attest that they're intending to own or occupy, okay? And if they're not owner occupying, and there's a current renter in the property who attends the auction, or otherwise gives notice within 15 days, they have a right of first refusal, meaning whatever the auction price was, that the tenant can match it. Okay, so that's a pretty good kicker. There's another one though here that I was a little bit shocked by. I mean, I think it'll be a pretty rare instance where the tenant steps up, okay, to in that 15-day period. But I'm looking at this other one here, 45-day window to price match for other bidders who would occupy. So again, the bias here is towards owner occupied rather than hedge funds amassing vast portfolios of rental properties through foreclosure, freezing out all of the potential buyers who would be owner occupiers, right, on the discount market. Well, now they can go to the auction, and if they get outbid by a hedge fund or some other, big real estate, investment trust or whatever, they can price match and go get financing and submit their offer, and they can take the property away theoretically. I haven't seen any of this in practice yet, but I'm real curious, and I'm going to be paying attention to see how it shakes out. AB 3182. This is another strike at the lack of inventory. In this case, tenant inventory. The homeowner association laws after AB 3182 last year, now they must allow at least 25% of their properties to be rented. So before the HOAs started enforcing excess rental, laws, they need to look at AB 3182. It may be that they're in violation. So then they would have to demonstrate that 25% of their properties are rentals, and that they need to, now they can go ahead and whatever those anti-rental, prohibitions are, to be re-examined at that point. It'd be an interesting area. I didn't include something else, but I should. I'll mention it. Related to homeowners associations, this is kind of more of a niche problem, but there's a new law that the elections for these homeowners associations need to have a monitor. Essentially, they need to hire somebody so that these elections are monitored, and they'll certify them as being fair, which is an important issue for landlords and tenants. It's also something that if I'm involved as a buyer in a real estate transaction, I want to get the homeowners association minutes for the last few years. I want to see all the rules. I want to get copies of the CC&Rs, and I actually want to read them. Okay, believe it or not, there's important information for people who are buying into HOAs there. And one of the things that you may find is that their elections are, well, let's just say dog and pony shows, okay? You want to make sure that, you can see that they, have a good track record in how they manage, their affairs, because you're buying into that universe, particularly, and you also want to know whether, if you're planning on renting the property in the HOA, whether they meet the 25% of the property's rented criteria already, and you may be barred from being able to lease your property, or there may be other rules that impact I'll also mention AB 38. This is hitting me on the transaction side and also the construction side. There's a fire notice disclosure to new buyers in high-risk fire areas for homes built before 2010. What's interesting in this notice, and why I'm saying it's hitting me on the construction side of our practice too, is because there are recommendations for how to fireproof their home that are included in the disclosure. And so, those are recommendations that you want to hire qualified contractors who have experience in fire mitigation to handle, you need to have a pretty high level of understanding of that and be up on your current codes, to do that. So if you're dealing with any of those issues and you're having problems with your contractors in that context, you can call me. Or you're a contractor and you want to get into that area, call me and we'll talk. AB 1885, this is important information in bankruptcy contexts and also creditors collection contexts. They've increased the homestead exemption for debtors up to the amount of the median for the county, or 600,000, whichever is greater. So right now in LA and Ventura County, Orange County, a good number of the major urban counties are up over 600,000. So the homestead exemption is 600,000 for those counties. That is also something you should be aware of in the 363 sale context too. That complicates a 363 sale where you're trying to identify a property that may be available for acquisition out of, you should keep in mind the homestead exemptions as well. Finally, let's talk a little bit about Prop 19. Prop 19 is this latest proposition related to property taxes that allows Californians to sell a home. And if they qualify, then they can buy a house and take their property tax basis with them. They can do that up to 3 times even. They must be 55 years old or have severe disabilities or have lost a home in a natural disaster to qualify. I haven't done the research yet to see Prop 19 passed before COVID, whether COVID-19 actually qualifies as a natural disaster. But I'm suspecting that it would. But if anybody has that issue that they've lost a home, and they're trying to extend their property tax benefit if they're going to buy another one, we can talk about it. So, and I'll look into it. The qualifying buyer can buy a more expensive home than the one they sold, and blend the taxable value of their new house with the value of the previous property, which is an interesting puzzle from a mathematical standpoint. I'm sure there's formulas for it. I've not been involved in any transaction yet that does it, but you should be aware of it, that there is a process for that. And presumably the county, wherever you will be, will have that reassessment function as part of their, but you'll have to disclose that in the forms and make sure you properly fill out your disclosure forms for, the property tax information, when you submit it to your local county where you purchased the home. So that's it. I think I've covered everything that I wanted to here. Again, my name is Stephen Sanders. I'm a partner here. I am fortunate enough to handle construction and real estate matters here, and also business entity formation and issues like that. So I don't have any questions. So you get the benefit, and if you're watching this on video later on, you can just reach out to me and call me at that number, 805-306-1100, extension 128, or feel free to email me And, I'll answer your general information questions. If it's requires more specific information, then I'll send you a retainer agreement for general counsel or corporate counsel representation. Okay, thank you so much. Appreciate your time. Bye-bye.